And Mr. Macur, reviewing over the short adjournment where we were up to, we won't need to trouble you for any submissions about the IMEG report.
I'm grateful, thank you, my Lord. Well, before I turn to my submissions before the adjournment, I was asked as to how many appeals there were.
Yes.
And I've been given information that last year there were 1,175 AFCS appeals, and it's been over 1,000 the last few years, so 1,605 in 2022.
Right.
There are also appeals still or separately under the War Pension Scheme, but specifically for the AFCS.
Right, so an appreciable number.
An appreciable number, yes.
Thank you very much.
So before the short adjournment, I had finished making my submissions as to how the respondent says that the scheme should be interpreted. And very briefly, the essence of the submission is that of the three categories we've been looking at, the first essentially relates to those who are unable to work in any paid employment until retirement age. The third relates to those who can work regularly, but in less demanding employment than they are qualified and have experience for. And the middle category is for those who can neither work regularly, but nor are they people who are unable to work at all until retirement. So the essence of the submission is that regularity is the key difference indicated by the footnotes between the descriptors. It is of course accepted that there may be circumstances, my Lord puts in, where a case simply doesn't fit in these categories at all, but where a footnote does give guidance in respect of ability to work, it is regularity which is the key difference. The only other point that I wanted to add to that is that I should emphasise that a point of, I think, actual difference between myself and my learned friend is that he says that not only does he not agree that regularity is necessarily a difference, but he also says there is an alternative in A, which is the diminishing capacity for work. And in my submission, that's not right. I said that the wording in footnote A doesn't suggest deteriorating ability to work. It simply refers to, over time, someone who can work in less demanding work. It is impossible to get diminishing capacity for work from the word less, because the word less refers quite clearly in my submission to less demanding than work you're qualified for, nor can you get it from the words over time, because that simply makes clear, or more clear, that the descriptor is dealing with a situation where someone may not be able to work at the moment, but it's not that they can't ever work until retirement age. Over time, they may be able to work in a less demanding job. So that's my submission as to broadly how it should be understood. And then I was going to turn to how the tribunal dealt with it, unless there's questions at this stage.
No, thank you.
So then I'm going to start with the first tier tribunal, which I can deal with quite briefly. And their judgment is at page 68 of the core bundle. But ignore the first couple of pages for these purposes. At page 71, we have paragraphs 13 and 14. Paragraph 13, recognised by the first tier tribunal that it had been accepted by the Secretary of State, the condition was permanent, and that it caused at least a moderate functional limitation or restriction. So he's working in a less demanding role than that's appropriate to his considerable experience, skills and qualifications. And they went on to say at 14, the only issue therefore for the tribunal was whether in fact, as of the date of decision, his illness caused severe functional limitation or restriction. And then they go on to say in order to determine that, we have to focus on whether he's able to work regularly in a less demanding job, the wording from footnote B, or rather whether over time since the onset of his ill health, he's able only to work in less demanding jobs. They then go on to set out the factual background before coming to their conclusions at page 73, paragraphs 27 through to 30, which I think the court indicated it had the opportunity to read. But I just make these points. In paragraph 27, the First Tier Tribunal recognised that it is not easy to interpret between the two descriptors using guidance from the footnotes in this case. But I look to the last sentence of that paragraph. So having said that, they thought carefully about the distinction. So which is the descriptor that best describes Mr. Pearson's limitations? And in my submission, that is unimpeachable as a statement of the legal question the First Tier Tribunal was supposed to be answering. And they go on in my submission to make entirely unobjectionable analysis, saying, yes, he's working in a less demanding job. Is he working regularly in a less demanding job, or has he over time been able to work only in less demanding jobs? And then they go on to consider that at 29, as you can see. And I would endorse what's said on the fourth line of 29. The distinction between the two descriptors appears best described as the difference between able to work in a steady, regular fashion, albeit in a much lower level job than the one in which the appellant's qualified for, or the ability to only work in less demanding roles, with an implication that the work will not be regular and there may be a series of intermittent roles. And in my submission, that's a natural interpretation of the guidance given to the tribunal by the footnotes, that is it someone who can work in a steady, regular fashion, or is it not? And they say the implication, it won't be regular, maybe, I would say it's given as an example, a series of intermittent roles. They then went on in paragraph 30 to expressly accept that the descriptors are not mutually exclusive. So they didn't, as I think was suggested earlier in respect of the Upper Tribunal, work their way up through the list and then stop at the first one that appeared appropriate, that they specifically considered and recognised that they're not mutually exclusive, but concluded that the most appropriate descriptor was the one currently awarded. And they want to effectively repeat what they've already said, and to emphasise at the end that his ability to work since discharge has remained relatively consistent and stable. So in my submission, as a matter of legal approach, that is entirely appropriate and entirely correct. The Upper Tribunal, of course, was deciding not the...
Well, just before you move on from the First Tier Tribunal, could we just go back a moment, please, to paragraphs 27, 28, 29, which you were just addressing us about. And I just want to understand the practical application of your submissions in the context of those who suffer permanent mental disorder resulting in functional limitation. I'm just trying to think of the circumstances in which such a person is capable still of employment in less demanding jobs, but isn't capable of continuous employment. I mean, is what's contemplated somebody who will be able to work for a bit and then have a breakdown or a relapse and have to go off for a bit and then come back on a bit?
That's certainly a possibility. So
I agree it's a possibility. But
these appeals, as you've heard, are based on medical evidence. It would not be surprising to have a report from a consultant psychiatrist that says, well, this person, for example, can't work at the moment, but they're doing well in their recovery. I'd expect them to be able to work a year from now, but I can't be sure whether they'll be able to continue that or whether they'll need to stop again. Wouldn't be unusual.
But won't it always, or always is an exaggeration, but won't it very often be possible to say, to add to that hypothetical report, of course, if he dropped down to a much lower role, he'd be able to work regularly.
Well, if, going back to the definition, if they think the person can work regularly, then it may be that the tribunal then probably would need to find that in fact the appropriate descriptor was moderate, because it doesn't require in footnote B that they are working regularly in a less demanding job, but that they're able to do so. So if the evidence is that they are able to do so, even in a job that's perhaps of lower status or less well paid, in terms of the scheme, my submission is that that is likely to be where they naturally fall. I've been thinking about that point, my lord, over the break in response to my lady's questions. That, for example, if a job is very menial or it's particularly far out of the person's experience, but the way that the Upper Tribunal in this case dealt with that, as we'll see in a minute, is that rather than saying, well, it's regular, it counts, but we're going to step back and say it's not moderate, it's severe, what they've done is they've taken a view as to what regular imports. So it's regular both in terms of sort of minimum level of frequency, but also they endorse what the first tier tribunal said about there being a de minimis level for the work.
Yeah.
And there may be an argument that if work is too far removed from what someone can be expected to do, that is not less demanding work that they can do regularly. That is something completely different.
Okay. Thank you.
So, how could it not be less demanding work then? If it was such a large difference from surgery to glass connecting, of course that's less demanding. So how can you apply the de minimis rule there and say, because it is so different, it can't be regular?
Probably, I'm not sure in that example I would accept it would be. And I don't want to offer a submission on the hypothetical, but the point, or certainly one of the points of the work being less demanding in the context of someone who has, using this wording, a mental disorder, is that the work is likely to be less stressful.
Yes, but can I just take you to paragraph 29
Yes.
of the first tier tribunal's judgment? And it's the last sentence, or the ability only to work in less demanding roles, with an implication that the work will not be regular and there may be a series of intermittent roles. So suppose the intermittent roles were nevertheless regular, so that somebody said, well, I'm going to do seasonal work during a circus or something like that. And so I will go to different places and I will do different jobs. I'll go to different parts of the country and follow farming and all the rest of it. That would be regular.
It might, I mean, for example, someone might take up landscape gardening.
But in that particular instance, the first tier tribunal seemed to be saying that a less demanding job has an implication that the work will not be regular.
They do say there's an implication by the absence of the word regular that it will be not regular and may be intermittent in B. That the less demanding, that those words are exactly the same in both cases.
Well, quite. So if they say, or the ability only to work in less demanding roles with an implication that the work will not be regular, it seems to be saying there that the regular applies to the frequency, as you've said, but also attaches itself to the level of employment which the subject of the application has obtained. And if this really is to be read literally, it seems to be saying we imply that regular is defined also, not just by frequency, but by the level of the job.
That's not how I read it. I read the introduction of the words less demanding as simply including those words from the test. They've, again, it's unfair to be
But how
hypercritical.
can there be an implication that work will not be regular? It's the implication.
Yes. So it's less demanding, but we know it's less demanding. It has to be less demanding in both boxes. That doesn't help us. But what they do say is with an implication that the work will, and they use the word will.
Oh, so I suppose they could be referring to the nature of the work itself rather than in general, that every less demanding role will be irregular?
Well, it will be not regular and it will be less demanding. So if, for example, Mr. Pearson had been able to continue as a surgeon, but less regularly, he wouldn't fit within this footnote.
So he would fall within A rather than B?
He wouldn't neatly fall within either of them because he wouldn't be someone who was unable to undertake work appropriate to experience, qualification and skills.
Well, so if Mr. Pearson started to do chiropody or to remove ingrowing toenails, that may be thought to be less demanding than operating ear, nose and throat. But you're saying that on that basis, if he did not do it regularly, he would fall within A rather than B?
Yes, I mean, to take his current example, he works as a medical member in a tribunal that requires use of his medical qualification and experience. It's not acceptable, it's not commensurate to his experience qualifications. It's not work as a surgeon, but it is work that requires him, as I said, to be a doctor. If he was only able to do that sometimes, he was, well, I can do 3 months now, but I'm not sure whether I can commit to longer, or I might be able to do some next year, rather than I can do a day a week, then yes, you would, on the face of it, he would be an A.
And suppose, therefore, the situation was not as it is now, where there's a demand for medical members of the tribunal, and Mr. Pearson was there saying, I'm willing and able to work for longer, but you call me at a hat drop, the morning saying somebody's dropped out, can you come along? And I only get 3 1 week and none the next, and perhaps over the year I get 6 in 2021, I've got 4 in 2022. I mean, is that regular?
So he'd be at risk of not having that work. Then he may well not be able to work regularly.
Well, he's at risk at not having the work from a tribunal at any time, isn't he? As long as he does 15 days.
Well, the finding of the first tier tribunal was that the work that he does is steady and regular. There's no suggestion, and it's not been submitted on his behalf, that is going to...
No. I'm testing out the theory rather than the facts. But it seems to be that there's a very, very narrow definition of regular that just... I mean, it's more than being arbitrary. It does start to fall over the edge, doesn't it, into, well, almost ridicule with respect, that you can have such a different situation as to, depending upon whether or not someone can get the work.
But I think all I can say in response to that is that these are very broad categories, and the fact that on any view, someone who can work is able to work regularly in a less demanding job would apply equally to someone who works 1 day a week, to someone who works full-time in a less demanding job.
Yes, but if it's 1 day 1 week and no day the next week, that's irregular.
There comes a point where it becomes irregular, yes, I agree. But the finding, we say principally that was a matter for the tribunal to determine, is a day a week regular, and they considered that carefully and said, well, this is enough.
Okay.
So the additional point I made is that in my submission there is no implication of deterioration that's implicit in footnote A. There's nothing to suggest that this is implying as a test someone whose condition is getting worse over time. So having dealt with the first tier tribunals, I'm going to turn to the upper tribunal. So at page 38 of the again, page 38 of the bundle. So to endorse brings me to the point I made earlier, that it is clear, in my submission, that the tribunal correctly identified legal approach. So they recognise specifically at paragraph 19 that circumstances may be described by more than one descriptor. The answer may not be clear, arguments may be made either way, but it can't be both moderate and severe at the same time. It is one or the other, and it's the task of the decision maker or tribunal to determine which it is. It does so by considering all relevant evidence and then determining which of the two most accurately describes the limitation. It's therefore most appropriate. And then, I believe 20 aside, I think 21 indicates that the first tier tribunal asked the correct question and approached it correctly, and I've taken you to the passage in the first tier tribunal's decision. The upper tribunal then looked at the distinction, and paragraphs 25 through to 26, which I know you've read, deals with this and the argument that regular should not mean someone might be capable of regular work, and that shouldn't mean that it's not a severe injury for the purposes of the table. And 26 takes a bit of care in reading, but we go to the fourth line down. Footnote B uses the word regularly to describe a qualified claimant's ability to work in less demanding jobs, whereas footnote A does not. The use of the word regularly must be taken to have been deliberate and intentional. Footnote A must therefore be read as not including jobs that might fall within footnote B, as being ones that the claimant is able to do regularly. To read it otherwise is to ignore Parliament's deliberate use of the word regularly in footnote B and to admit it in footnote A. And we do say that that's correct. That is, as I've said, the key difference between footnote A and footnote B. In respect of the wording, it is the significant difference. That if you are able to work regularly, footnote B suggests that moderate is the appropriate descriptor.
But this does then create the absolute dichotomy. If you can work regularly in however lowly a capacity, and however many painful years it's taken to get down to that very lowly stage, you're only ever in moderate, even if, from any objective point of view, circumstances cry out for an assessment of severe.
And to the extent that that is wrong, there are in principle two ways it could be dealt with. One is for this court to say, well, decision makers should not necessarily adopt the footnote, but they need to stand back from the footnote and decide for themselves, is it actually moderate or is it actually severe? That, of course, with a scheme like this, creates significant risks. The way that the Upper Tribunal dealt with it, it seems to me, is to instead look very carefully at what is meant by regularly. It's paragraph 35, page 41, where they do that. So they, having sort of dealt with the 1 day a year example, so that would be out. They also agree with the first tier tribunal judge that only some very limited capacity for part-time work might be disregarded as de minimis. So they do recognise that if it's very limited capacity, part-time work, that might be de minimis. And it would be open, of course, to someone to argue as to exactly what the scope of that is. All I need to say for the purposes of this is it's not working a day a week, every week as a member of a tribunal.
But what would the position be if Mr. Pearson had taken the 3 months off when he was advised to? Where does that fit into the scheme of regular or intermittent?
That would not that would not have changed because that was prior to him becoming unable to carry out work which he was suited for his qualifications. So he was still practicing at that point.
Right.
He was advised to take time off, the way it's summarised by the Tribunal. He didn't. He continued to try and work, tried to go back to work in both of his practices. He was not able to do so, and eventually he's discharged and he doesn't work either in the NHS or private after that as a surgeon. But the question, is he able to work regularly in a less demanding job, is addressed by the Tribunal. I took you to what this court said in Duncan right at the beginning, is addressed by the Tribunal taking into account all of the evidence. So the Tribunal appropriately takes evidence as to what Mr. Pearson is able to do now, and makes its assessment that he is able to work a day a week in the Tribunal. That's what he's doing. That's steady, regular work.
May I ask you in that regard about paragraph 35? Because you see, in this paragraph, the Upper Tribunal defines regularity by frequency. Because that's how they try to distinguish between the regular once a year or twice a year and the situation where it's once a week. But I mean, on the basis of the argument put forward, that if that's what was meant, that's what would be said. Regularly and frequently?
I don't think I can do better than the Tribunal did at the paragraph before, where they grapple with this, and they say regularly denotes something other than intermittent, something which is steady and reasonably frequent. So they say that regularly includes an element of frequency.
And where do they get that from?
Their judgment as a specialist tribunal, I think, is the only answer I can give to that.
But it's not in the statutory instrument, is it?
Regularly is not. Neither of us have found anything that will help you in the legislation or elsewhere.
No, thank you.
But the respondent's
it's a very awkward term, isn't it? If you're a season ticket holder at a rugby club, you can say, well, I go regularly to the match. I go to every home match. But it might only be 12 in a season. Is that regular? 12 times a year? At uneven intervals? No, it does seem to me that there's some muddling up as between consistency, frequency, periodic regularity in the sense of every week rather than twice every 20 days or something like that. But anyway, you say that's all a matter for the judgment of the specialist tribunal in all the circumstances.
Given what they have to guide them, we say that paragraph 34 is the appropriate approach. That it's a sensible working definition, which they made clear is not a strict definition.
Yep.
But to be determined, taking on account all of the factors in a case. I wouldn't want to speculate why the makers of the scheme chose regularity as the barometer rather than frequency or intensity or remuneration or any other measure of work that can be done. Presumably there were reasons, but I come back to the point made by this court previously that the scheme is what it is, in fact. So, paragraph 26, I made the point that they were right in my submission to say that regular is effectively the key indicator, and if someone can do something regularly, that indicates that they're not in A. Yes, in paragraph 30, so I wanted to highlight it on page 40, there was an argument that they addressed that, in effect, a requirement of it being intermittent, being imported into A, and the Upper Tribunal is quite careful to say that we're not reading the requirement of intermittent into A, and they give an example of someone who might be able to work intermittently but can't do so regularly, but someone vice versa. So that they're not putting in, they're not impermissibly adding a word into A that is not there, or a requirement into A that is not there. All they're doing is saying that the work, if it's regular, should go into B. And then at 31, they apply that to the approach that the first tier tribunal took. And indeed refer to the sentence that my lady took me to, and emphasise the word may. So it doesn't have to be a series of intermittent roles. The work will not be regular, that's the key feature, but it may be a series of intermittent roles. And finally, it was put that the tribunal had erred in terms of referring to being compelled to adopt the approach in B, and so on. The paragraph I'd already spoken to the opening or early paragraphs at 19 to 21, where they set out appropriately the correct test. And then at paragraph 45, when they come to their conclusion, page 43, they, in my submission, repeat that. The first tier tribunal's task was simple, namely to determine which of items 1 or 2 was most appropriate. And they go on to then analyse the bits that are not in dispute. It's a less demanding job. He's unable to do his previous jobs for his experience. But the job that he was doing was sitting as a fee-paid medical member, etc. And in my submission, the Upper Tribunal read fairly as a whole in that judgment, is doing no more than explaining that the first tier tribunal considered both of the options, decided on the most appropriate, and didn't make any error at all when they did so. So to deal then, I think briefly with the specific grounds, in respect of reading in a requirement for work to be non-regular, I've dealt with that in some detail, but we say that the key feature of B is that work is regular. If it is regular, it's going to be B, absent some other reason. So the distinguishing feature is B is for regular work, double A is for those who can't work at all, and A is for somewhere in between. In respect of the second part of that argument, that the tribunal failed to consider whether this was a diminishing capacity for work over time case, the answer to that is first, that is not what footnote A is dealing with. But in any event, it isn't the situation in this case. I'll come back to that when I deal with the trajectory point. The second criticism, I think, goes with the first, so whether the tribunal used regularity as the sole distinguishing feature. It is the key difference between the provisions, as I explained. And then the third, which is the trajectory point.
Sorry, before we get there,
Yes.
so you keep saying key.
Yes.
Regularity is the key. Does that in any way address the ground which says that it was used as the sole? Key and sole aren't interchangeable, are they?
No, I mean, in this case, once the tribunal had found that Mr. Pearson was someone who was able to work regularly in a less demanding job, my submission is it's perfectly
You say that's determinative.
It is
Yeah.
B. That decides it in this case. I hesitate to agree that it's the sole criteria. because it's been put to me, there will be cases that don't fit naturally into either of those. There are also the cases that the tribunal had in mind, where perhaps technically someone can work regularly every Christmas Day, but it's clearly not what is intended. So then moving to the trajectory point, the first problem, my submission with that argument, is that that depends on the severe descriptor, having within it an element of deteriorating capacity for work over time, put by the appellant. And as I've said, that is not in my submission an appropriate reading of A. It's not, the words don't support it. But secondly, that doesn't assist the claimant, the appellant rather, in any event. He refers to paragraphs 15 and 16 of the first tier tribunal decision and says, well, that shows such a trajectory, but with respect it doesn't. That shows rather someone who, in respect of their original work, the work that's appropriate to their qualifications and experience, that it was over a period of time that they were unable to do that. And there came a point when Mr. Pearson was no longer able to work as a surgeon. But there is no evidence, and certainly no finding, that in respect of his ability to carry out less demanding work, that is deteriorating over time. His work with the tribunal has remained constant. This morning, in fact, clarification, he works more than he did in 2013 because he was busy with his other occupation.
Sorry, I don't understand that, I'm afraid. One might equally say Mr. Pearson's ability to wash glasses in a pub hasn't diminished over time. He's been able to do that since he was about 15, and still is, no doubt.
I've obviously not expressed it very clearly. As I understand the point that's being made in this respect, the submission as to footnote A is to say that this deals with someone who can't undertake work appropriate to their experience, can't work as a surgeon, and in respect of their ability to work in less demanding jobs, A is concerned with those who are only, to use the words in the IMEG report, increasingly unable to do even less demanding jobs. And that's not Mr. Pearson, because Mr. Pearson is not increasingly unable to work as a member of the tribunal.
But he's increasingly unable to work as a consultant ENT surgeon. When one reads his history, I don't wish to say anything that's going to distress anyone, but what the 2 paragraphs of the first tier tribunal's judgment recount is a really unhappy period of years, with Mr. Pearson gradually becoming less and less able to do the many, many things he was able and qualified to do at the time of the onset of the illness.
But this is future-looking compensation. It's a given for any of the first 3 that Mr. Pearson has reached a point where he can't work as a surgeon at all. That has to be the case even for B. If he could still work as a surgeon, he wouldn't be eligible for moderate either.
No.
So it's not his deteriorating capacity to work as a surgeon that differentiates between AA, A and B, because for any of them he has to not be able to work as a surgeon at all. So I may be wrong, I had understood that the submission being made against me was that A will include someone who has a deteriorating or decreasing capacity for the less demanding jobs, and that Mr. Pearson is in that category. And I don't accept either premise. If I've misunderstood, if there were a doubt, if it said that because in the past the deterioration in his ability to work as a surgeon took a period of time, then I would agree with the Upper Tribunal that's irrelevant, because it's a precondition for all 3 of them that he can't work as a surgeon at all. The difference between the 3 categories is what work is he able to do after that.
the history that's recounted at
Yes.
paragraph 16 and 17 of the, or particularly 16 of the first year tribunal decision, is somebody who starts out as a full-time consultant and a whole variety of other roles, and he gradually divests himself of those roles and moves to part-time working in terms of his consultant role, at the end of which he's had to give it all up. And at the start, he was able to undertake work appropriate to his experience, qualifications and skills, which is all these various roles. But as time went on, his mental condition meant that he had to stop some of them and gradually stop them all. Why doesn't that bring it within pay?
Because having to stop them all, having to not be able to do any work appropriate to his experience and qualifications, doesn't help you choose between AA, A and B. That's the first requirement for all three of those. So even for B, even for moderate, so to get the 50% of your 50% payment, he still has to show that he has a functional limitation where he's unable to undertake work appropriate to his experience, qualifications and skills.
Yes, I follow that, but I thought you were, I must have misunderstood your submission. I thought you were saying that you have to look at the point at which you can't do anything that you used to be able to do before. And that's as it were, your starting point. And I'm asking whether, as is on the facts of this case, it's a gradual process.
In my submission, that makes no difference. And I may have misunderstood the point being made against me. I had not understood that the deterioration being relied upon was in respect of his work as a surgeon. I'd understood that it was in respect of his residual capacity. But it doesn't help the appellant in either event, because if his deterioration, if he'd been able to continue as a surgeon, perhaps give up some of his roles or go part-time, he wouldn't be eligible for any of those three. So we wouldn't be looking at less demanding work, because he wouldn't get over the first hurdle, being unable to undertake work appropriate to his experience.
But wouldn't that be triggered by the fact that he was medically downgraded, reducing his occupational responsibilities? So surely that falls within the definition of not working in accordance with his experience. Qualifications, they'll be the same, but experience, at the level that Mr. Pearson was, he was training others. He was working overnight. So his experience in that case has been downgraded. So he's not working to the level of his experience.
It's a different point, but it's not a point the respondent would accept. The respondent would not accept that someone, for example, who is a busy consultant surgeon and they're on call and they're perhaps in charge of a department of the hospital, but because of an injury, they can't work on call, they can't have the management responsibilities, but they are still working as a surgeon. We would not accept that that means that they're unable to undertake work appropriate to their experience, qualifications and skills, because they still would be doing work which is appropriate to their experience, qualifications and skills.
But in a lesser capacity.
But that's not, I mean, there are
It is a functional deterioration if someone is not able to work to the same extent. Or
restriction.
Yes. But you say it's not the point of this appeal, and I accept that. It was just to counter one of your submissions that I made that point.
Yes, I mean, I noted that in the first tier tribunal, the Secretary of State had at one point said that working in the tribunal was in fact appropriate to experience, but the tribunal rightly said that's not consistent with the concession that the first part of this is met. And I say rightly, it's different working as just using your legal qualification to work in a tribunal to actually use your qualifications, skills and experience. But someone who can work as an ENT surgeon, in my submission, is undertaking work appropriate to their experience, qualifications and skills. They might not be benefiting from those to the maximum. They might not be as successful in their career as they would otherwise be, but that's not the same as, it's a very hard-edged requirement, unable to undertake work that's appropriate to their experience.
But it could mean the difference, couldn't it, in rank? So that if, for example, if Mr. Pearson had gone to the relevant line manager and said, well, look, I can still do some surgery, I can still do some consultations, but I'm afraid that you're going to have to relieve me of X, Y, and Z. Then presumably his line manager, Admiral of the Fleet or whatever, would say, well, I'm sorry, you can no longer remain at the rank you are.
I'm sorry not to be, if you would like an answer.
No, it's just it's putting the point that the fact that you retain your ability to do surgery doesn't necessarily mean that you are working appropriate to experience, qualifications and skills if you've had to scale down.
I'm not sure whether people get demoted if they're medically unable.
All right.
So that may be that's why I'm hesitating to answer.
It's a distraction, Mr. Mankell. Move on.
But I think more fundamentally that there is a difference in that the respondent would not accept that someone who is still able to work as a surgeon is not able to undertake work appropriate to their experience, qualifications and skills. It doesn't say, it could have said, unable to undertake their previous work.
All right.
But it doesn't. So for those reasons, we don't say that any deterioration, whether it was a fast or a slow process by which he came to a point where he was unable to undertake work appropriate to his experience, doesn't help you to then decide between the three categories that makes him eligible for. The difference between the three categories is in each case, what work can he now do? First is none. The second is, over time, less demanding jobs without further explanation. And the third is work regularly in less demanding jobs. And that's the difference. And so to the extent that there is a trajectory argument in my submission could only relate to that. And I don't accept that you find the support for that in any of the footnotes. Just turn my... I'm grateful for the indication about the IMEG report. Is there anything else?
Well, did you want to address ground 3 in relation to the appropriate period to be considered?
Yes. So in respect to the appropriate period, we endorse what the Upper Tribunal says at paragraph 45, which is where they in effect make the point that as I understand it, the point that I've been trying to make, which is that the key issue is, was he unable to do his previous job? Once that ceased, the only evidence is, well, what can he do now? And they say, well, the only job he was in fact doing, as of the date of Secretary of State's decision, was sitting as a fee-paid medical member. So the date in my submission makes no difference. If he had been working more as a medical member of the tribunal, and that had reduced, then it may have become relevant, but that's not the evidence. The position is that work either increased or stayed the same. And so looking at it, whether one looks at the time period in which it took for his work as a surgeon to come to a halt, it doesn't make any difference because it doesn't help you on the test.
Well, but why in the middle of that paragraph, why is the period between 2009 and 2017 irrelevant? Given that what one has to start with is his experience, qualifications and skills as at 2009,
Yes.
one then has to draw a contrast with his position as at the time of the decision in 2018. So why are we to ignore the first 9 years of that?
The point that the tribunal is making, as I understand it, is that the evidence about those jobs in that period is evidence as to his changing role as a surgeon. So it's all evidence about the process by which he became unable to undertake work appropriate to his experience and qualifications. It doesn't shed any light on his ability to work in less demanding jobs.
Well, but surely it does, because say the deterioration in that period had been less than it was, then it would no doubt be said, well, he's able to do a greater range and a higher level of responsibility of still somewhat less demanding jobs. And as my lord has pointed out, at the start of that period, I don't mean this dismissively, but he wasn't just a consultant ENT surgeon. He was doing a host of other very responsible things. And if over the period we're discussing, he'd still been able to do all those other very responsible things, and the only thing he couldn't do was practice as a consultant surgeon, presumably it would have been taken into account, as it were, against him, that he retained the capacity to do all those other things. He could still advise people, he could still be a committee member, he could still travel to more distant first-tier tribunal sittings. So why is the converse situation, the deterioration in all those aspects of his working life, why is that to be ignored?
I'm not sure that's the appellant's case. The paragraph 16 of the first-tier tribunal, they talk about him working as a full-time ENT consultant with extensive additional responsibilities, which I read to be as an ENT consultant, as a senior consultant. The rest of that paragraph is all about his work as an ENT consultant. The only work that is separate from work which I say is appropriate to his experience, which is namely the work as an ENT consultant, is the following paragraph, which is his work as a fee-paid judicial office holder.
All right, thank you.
The only other answer I would make to that, my lord, is that, as I've said, there isn't in my submission anything in footnote A that highlights a deteriorating pattern of work as being a determining factor.
Yep, thank you.
Thank you.
Yes, Mr. Weber, did you want to reply to any of those submissions?
If I may, very briefly, my lord, I appreciate you've heard lengthy argument on a fairly narrow issue, but I simply have 4 points to make. The first, if there is any doubt as to what the appellant says trajectory, the term we're using in these proceedings, means, the appellant's case is that trajectory is measured by capability for work at the onset of illness. So what was the uninhibited person capable of through to their end point of capability? That is what the appellant says trajectory means, the level of work of which they are capable. That's why the full period from onset of illness matters. Secondly, if I may pick up on the point concerning what is meant by work that's suitable to qualifications, experience, and so on. And I think my learned friend gives the example of an ENT surgeon who perhaps reduces some surgical duties, but otherwise carries on with clinics, perhaps more minor surgeries. And the suggestion being that that person probably is not in less demanding work because their work is still appropriate to their skills and experience. I say, on behalf of the appellant, that is to attack the problem from the wrong angle. What this is about is looking at what somebody with those experience, skills, etc. is capable of. What is the full range? Are there aspects of that which they can no longer do? That's what we're talking about when we're talking about less demanding work. The Minister has accepted in Dr. Pearson's case that his role in the first tier tribunal is less demanding work. There's no doubt it's work appropriate to his skills and experience. His very qualification as a doctor is what makes Dr. Pearson appropriate for the role of medical member. But what it's about, and as the Minister must have acknowledged in that concession, is the fact that he cannot do all of the things that are appropriate to his skills, etc., because of the mental disorder. So in my submission, that is the correct way to approach the question of what is less demanding work. The third and fourth points simply go back to the first tier and the upper tribunal judgments. Firstly, the first tier tribunal, I accept, has asked itself the right question in the sense of which is the descriptor that best fits. But the problem, I say, is that having asked that question, the first tier tribunal turned its lens only to the question of regularity, whereas the descriptor required that at least it should look or cast an eye to what I'm calling the trajectory point. It may be that the tribunal would take the view that regularity was the trump card, but it still had to look at both elements. Fourthly, and lastly, the upper tribunal. It's been argued that the upper tribunal was correct to decide that regularity is the defining feature. The upper tribunal was perhaps firmer in that view than the first tier tribunal. The difficulty, I say, is that the example given by the upper tribunal when trying to explain how these descriptors might be differentiated in reality is what we find at paragraph 35, page 41 of the authorities bundle. And what the learned judge explains is that one approach might be to say that work ceases to have regularity such that it can properly be treated as de minimis. In effect, it's so irregular, we're not going to count it or include it. The difficulty with that, if it's right, is that if the work is so inconsequential as to effectively be disregarded, then that must mean the individual should properly fall into 1A. No work at all. Insofar as the thrust of the decisions and the argument before you today is to the effect that the severe category just naturally falls in the middle of the two descriptors that surround it, my submission is that just doesn't hold water, because there is no real middle on that analysis. That is why the severe descriptor is concerned with trajectory, either wholly or at the very least in addition to any question of regularity. Those are the only points I had noted to make in reply. Can I assist the court any further?
No, thank you.
No, Thank you very much. We'll just rise very briefly to take stock of where we are.
Either way, either way. I think we should get it wrong.
It's a bit like
Just ignore it. Oh, really? Right.
You know that?
That was.
Well, it's the president of the jury in the court last week.
Yeah. The Judge Advocate General.
Oh, no. Well, this is the Judge Advocate General, but then you've got the lay members who, in a military, the general effectively are
Yeah.
the board, and there's a president of the board.
Oh, I
and then
see.
the
It's
judge.
something different.
But they make the president do this.
Is there a
Because
senior
there's
military officer?
yeah. The judge does all the legal bits and the sentence, but it's the president who gives the
Yeah.
Interesting. Have you ever been to?
And the board participated in the sentence decision.
I went to North.
Okay.
It was very nice. You were treated very well.
Yeah.
Given that.
Yeah, you get
People
cups of
salute
tea.
to you.
It was a contrast when I first joined. I hadn't been in the magistrates before, and then like suddenly there's all these facilities.
It's always a mythical story of convention taking hats on barristers who've taken their wig off and not sure whether they're supposed to enjoy it.
Okay, really? Isn't
Yeah,
it?
the answer is they
No,
don't.
you don't. Yeah.
You see, just a sort of freelance press.
Yeah, I think so.
Mr. Bagnall, having it occurs to us that we've neglected to give you the opportunity to say anything you might want to say about what course we should take, depending on the outcome of the overall view of the appeal. We invited submissions on that from Mr. Webb and meant to invite them from you, but I'm sorry, I overlooked it.
I should have addressed that. Robert, we don't disagree with Mr. Webb. It's a matter of the court. If you can decide this for yourselves.
You're not actively urging us to do so.
No.
No.
I mean, it may be the situation in which you might be more minded to do so would be if you felt that the first tier tribunal approached matters appropriately, but there was a flaw in the Upper Tribunal's analysis, but that nevertheless there was no error of law. That might be a decision you were willing to take, but we don't. It's entirely a matter for the court.
All right. Thank you very much indeed. Well, we're very grateful to both counsel for their very helpful submissions, and also to those behind who've assisted in the preparation of the appeal. We will reserve judgment. We will, as soon as possible, circulate a draft. That'll be an opportunity for you to assist us with any typographical errors and the like, but not, please, further submissions. And our intention will be to hand down remotely in due course, unless anything arises which suggests a need for a hearing. When we invite corrections of any typographical errors, etc., we'd be grateful if you would also try to agree the terms of an appropriate order. If there are issues between you at that point about any consequential matter, then brief written submissions, please, which we will aim to resolve in writing unless we feel a hearing is necessary. I think that covers everything.
Thank you.
Mr. Manknell, I'm afraid from your point of view, it's highly likely we will get this judgment out before March the 18th. So it will not be a judgment which bears the magic letters next to your name.
Thank you.
But may we take the opportunity to congratulate you on the forthcoming appointment.
Thank you very much.
And but by way of, if I may, encouragement to you both, you may have noticed that in the only case you've been able to find previously relevant to this topic, of the 5 counsel who appeared in this court, 3 are, as things stand, on the High Court bench. So onwards and upwards, gentlemen.
Thank you very much.
Thank you very much.